now listen to our colleague, Honorable Tampuli Hassan. You have 7 minutes.
Thank you very much, Mr. Speaker, for giving me the opportunity to contribute to the report before this House. Mr. Speaker, in doing so, I would like to seek your guidance on paragraph 6.18 on page 27 of the report. And Mr. Speaker, based on your ruling and your interventions in the course of the reflections that have been shared by prior speakers, I would like to seek your guidance, Mr. Speaker. The committee says, for instance, and I quote, "The committee raised concerns regarding the propriety of proceedings with the vetting process, given the pending legal suits challenging the removal of the former Chief Justice. In its response, the nominee affirmed that Parliament was acting fully within its constitutional mandate, emphasizing that the mere filing of a writ or an application for injunction does not automatically stay the performance of a constitutional duty unless a specific restraining order is issued by a court of competent jurisdiction." Mr. Speaker, it continues with the second, third, and fourth paragraphs. Mr. Speaker, with what we have here, and having regard to the fact that you have made your ruling, is it out of order if one continues to speak to this same report in accordance with the rules of this House? Mr. Speaker, I'd like to seek your guidance.
Honorable Member, I made a ruling earlier on this matter, not today. In fact, it was a written ruling I delivered here on this matter. And I say none of you challenge that ruling. And that ruling remains the ruling of Mr. Speaker and is binding on the House. So we can no longer go back to it. I was talking about my act, not the act of the nominee. Please, and I stay by that.
Thank you, Mr. Speaker. I'll be guided accordingly. Mr. Speaker, it has to be put on record that Justice Paul Baffoe, the nominee for the office of Chief Justice, was appointed to the Court of Appeal by His Excellency President John Agyekum Kufuor. Mr. Speaker, at the time that he was being nominated or appointed to the Court of Appeal, there were High Court justices who had served in the High Court long before him, but President Kufuor found him suitable to be taken to the Court of Appeal. Mr. Speaker, subsequently, after 2 years, even though Justice Paul Baffoe met his seniors at the Court of Appeal, President Kufuor again found him suitable to take him to the Supreme Court. So, Mr. Speaker, largely we on this side of the divide are not opposed to the nomination of Justice Paul Baffoe for any personal. Listen to me, Mr. Speaker, we are not opposed for any personal reasons. We are opposed to his nomination based on principle of the pendency of matters by the Justice Takonu, which are still pending before courts. And we have taken this principal position just to let you know that we do not have any issues. In fact, we don't just want to join issues with you, especially regarding the matter of Justice Paul Baffoe. Mr. Speaker, we have to look at this matter within the framework of the preamble of the 1992 Constitution. Mr. Speaker, we the people of Ghana, in the exercise of our natural and inalienable rights to establish a framework of government which shall secure for ourselves and posterity the blessings of liberty, equality of opportunity, and prosperity. Mr. Speaker, it continues, in a spirit of friendship and peace, with all peoples of the world, and in solemn declaration and affirmation of our commitments to freedom, justice, and probity and accountability. The principle that all powers of government spring from the sovereign will of the people. The principle of universal adult suffrage, and Mr. Speaker, my emphasis, the rule of law. Supremacy of the Constitution, equality before the law, and respect for the fundamental human rights and freedom of our people. Mr. Speaker, in terms of fundamental human rights of the people and access to justice, Mr. Speaker, embedded in that rule of law thing is the accessible and impartial justice. Mr. Speaker, we must be given usable opportunities when we think our rights have been violated to be able to vindicate our rights. Mr. Speaker, one of the things that we must advert our minds to is that when there are pending matters, it's important that I am allowed to finish the process before a decision will be taken that will prejudice my rights. And Mr. Speaker, we are not saying this because this is Justice Tokono, but this right must be available to every one of us and every Ghanaian. Mr. Speaker, fair legal procedures. Mr. Speaker, if I take a matter to court, I have every right to complete the matter before I'm told that my issue is foreclosed. Mr. Speaker, if matters are pending before courts and you leave the office, Mr. Speaker, Article 1446 provides situations where a justice of the Superior Court, including the Chief Justice, may lose office. Stated misbehavior, incompetence, and inability to perform the functions of the office. Mr. Speaker, what we are saying is that if we go ahead to confirm Justice Paul Baffoe and he becomes the Chief Justice, and in the event that the pending cases terminate in her favor, what happens to that office? Mr. Speaker, we anticipate that there will be constitutional nuclear meltdown, and that is what we intend to avoid.
Honorable member.
Mr. Speaker.
Honorable member, please. I don't know how many times I have to draw the attention of members to this matter. That is not what is before us. Finality of the rule of law is pronounced and is in the bosom of the courts. Legislative power, the power to make laws, is in our bosom. The Constitution added the power to approve, that is, give prior approval to nominees by His Excellency the President. And that is exactly what we are doing. As to whether our decision is the final rule of law, is for another body to determine. And so the proper venue, and I keep on emphasizing that, is not this house, it's the court. And so please, once you have the matters pending there, the matters will continue to pen there, and you can vindicate those rights there. The judiciary cannot say that because Parliament is considering a bill that may have some effect on a matter before the judiciary, they'll have to hold on until we pass the bill before they proceed with the matter. They can't say that. The same, I'm just putting it in simple language, that once a matter is before the judiciary, they can't say because that matter is before the judiciary, Parliament is stopped from also performing its function of lawmaking, of oversight, of these approvals and the rest until they finish adjudicating the matter. So we have to go on with ours. And that is exactly what we are doing. We cannot be stopped. I have given my ruling on this, and you are bound by it. If you are not, You know the rule in our standing orders. You know what to do. If you are not satisfied with that, you also have the courts to go and vindicate your rights. But so far as the matter before us is concerned, let's stick to that matter. Let's go on with that, and then later on you can proceed with whatever you want to do. But for me as Speaker, I preside. I don't judge. I preside. And I'll preside and make sure that what the rules say should happen will happen. At the end of the day, the House will be given the opportunity to take the decision. The rest, you can proceed on after that, please. So let's move on to the matter before us.
Thank you, Mr. Speaker. Mr. Speaker, I'm guided. Mr. Speaker, next I would like to refer this House to Article 1254 of the Constitution, where it says that the Chief Justice shall be subject to the Constitution as be the head of the judiciary and shall be responsible for the administration and supervision of the judiciary.
I told you about the timing. When there was the interjection, it stopped. It's automatic. It's not being controlled by me. Please, kindly give him 1 minute. 1 minute.
Thank you, Mr. Speaker. Mr. Speaker, what that provision provides for is that we are not looking at the Chief Justice capacity as a Justice of the Supreme Court, but as a head of the judiciary in terms of the human resource, planning, organizing, directing, control, and discipline of the judicial human resource, the judicial service staff, including even judges. Mr. Speaker, one would be not too far away if you ask the acting Chief Justice whether or not he will be transferring judges, whether or not if a justice of the Superior Court, conducts himself or in any way he will be taking action against the person, or whether or not any disciplinary action can be taken anybody as a judge or any staff of the judicial service. Mr. Speaker.
The 1 minute is over again. So, but honorable member, don't be worried about that, because even this constitution, when it was being drafted, it was said to be drafted by hairdressers. Now, when it was approved, the people who stated that the hairdressers were drafting constitution kept on applauding the good works of the hairdressers. So, and you have also done that today. It's just that politicians are a different breed of human beings. So that is the challenge we have in the world. May we proceed to the next person, and this time from the majority side, and that is Honorable Eric Opoku. Honorable, you have seven minutes.
Thank you very much, Mr. Speaker, for the opportunity to contribute to the motion before this House. Mr. Speaker, this House is witnessing inconsistency in its highest apogee. Inconsistency that has never been seen on the floor of this House, except today. Mr. Speaker, you recall that in the last year of Mr. President John Agyekum Kufuor, 2008, Justice Paul Baffoe was elevated to the position of Supreme Court Justice. And the Appointments Committee's report was submitted to this House for approval. Mr. Speaker, that day, records of this House indicate that the minority we see today, they were in the majority. And they extolled the virtues of this man right in this chamber. They described him as competent. They described him as competent, a man who has served this nation with dignity, an honest judge. In fact, they said a lot of good things about this man. Mr. Speaker, what has changed? What has changed? Today, the same person has been elevated, and now you are opposing his nomination. History will be the best judge. Mr. Speaker, again, I heard Honorable Enyimadu spoke about executive manipulation of the judiciary. Mr. Speaker, you recall that between 2003 and 2006, Justice Paul Baffoe was appointed to the Fast-Track High Court. He was appointed to the Fast-Track High Court, a court established by President Baffoe, tried some cases, and after some years, declared unconstitutional in the history of our country. That was the period of executive manipulation of the judiciary. That was the period. And it happened under your watch. And today you have the courage to sit in the same chamber and talk about executive manipulation of the judiciary. Mr. Speaker, again, you are ruling on the matter, on this matter, is fortified by this report.
Honorable member, please. May we listen to, yes.
Mr. Speaker, very respectfully, I stand on Order 122 to clarify a point. Mr. Speaker, we don't appoint to the Fast-Track High Court. We appoint to the High Court. So, Mr. Speaker, that clarification would have to be clear. There's nothing like we appoint to the High Court and not the Fast-Track High Court. When you are appointed to the High Court, you are then assigned to a division of the High Court. Mr. Speaker, this is the point. You don't appoint to the High Court.
Mr. Speaker, Mr. Speaker, Mr. Speaker, it is in the report, page 8. Page 8 of the report. Listen. Page 8 of the report. He was elevated to the High Court in 2000, serving at Sunyane and Kumasi between 2000 and 2003, and later appointed justice to the Fast-Track High Court. Is it the report? So what's your problem? So, Mr. Speaker, I was speaking to the report, exactly how it is captured in the report. Now, Mr. Speaker, you are ruling on the matter that while Parliament is discharging a lawful duty, no court action can stop that. Is fortified by this report. And it's interesting we raise this issue for Ghanaians to know. Mr. Speaker, paragraph 27 of the report.
Honorable member, your leader is on his feet. Okay. Yes, please.
Mr. Speaker, I have been trying very hard to get members on this side to listen to opposing views. I urge our colleagues to also pay attention and listen so that we can expedite action on this matter. I'm just appealing to our colleagues on the other side.
Honorable members, Please, we need to listen to each other. Honorable Doctor, he represented Parliament at our march against the judiciary. He was among the 11, and he ran all over the field without touching the ball. And he was substituted. So I understand that. Honorable members, please, we only consider and give prior approval to nominees of the President to the Supreme Court. The High Court and the Court of Appeal don't come before the House for prior approval. Please, that is the state of affairs. The process that he went through, I was minority leader. Concerns were expressed, but this was not a matter that came before the House for his approval or otherwise. Not at all. Please, let's go on.
Thank you very much, Mr. Speaker. Mr. Speaker, I was saying that reading page 27 of the report, under point 6.18, propriety of proceeding with the vetting process. Your committee has reported, and indeed they have cited two major cases, one involving a member of this House, Honorable Vincent Asamoah versus Attorney General, and the report reads, to substantiate his position, the nominee cited relevant legal precedents, including Baffoe versus Bank of Ghana and Vincent Asamoah versus Attorney General, both of which affirm the principle that the existence of a legal challenge does not suspend constitutional processes in the absence of an explicit court injunction. Mr. Speaker, these two cases.
Honorable member, I ruled on that, so let's move on.
Mr. Speaker, I'm moving on because our colleagues, when I raised the issue, that the same person, when he was brought here, they extolled his virtues. They said no, they are not opposed to his nomination, but they are talking about some legalities. And the basis of their argument is that there is a case that is to stop the proceedings of this House. And I'm reading this to fortify your ruling that they don't have basis. Their argument is baseless. They are only talking because they are in the minority and they want to be heard. Otherwise, they'll have no case at all to be even making noise in this House. The truth of the fact is that the man qualifies, he is competent. In fact, he is the first son from our region, Ahafo, to be elevated to this position. And the people of our region are solidly behind him. And so we urge our colleagues on the other side that you cannot oppose everything on this earth. You were here defending some few days ago. Now you are transmogrified.
Honorable members, we move on to the next person, and that is the last from the minority caucus, and the leader himself wants to take up that task. So I call on Osahene Afenyo-Markin.
Mr. Speaker,
Thank you for the opportunity to add my voice to this debate on the floor. Mr. Speaker, in making my contribution, I would want to, in addition to the report, rely on the certified copy of the verbatim report of proceedings that has been served on my good self by the clerk through the chairman. And for the avoidance of doubt, I would want to make same available to the table office for the record, because I'm going to rely on same. Mr. Speaker, that said, I shall proceed to say that for the first time under the 1992 Constitution, a sitting Chief Justice has been removed pursuant to Article 146 of the Constitution. Mr. Speaker, that removal effected on 1st September 2025, following recommendation by a committee chaired by His Lordship Justice Gabriel Puaman, has generated unprecedented litigation challenging its constitutional validity, procedural regularity, and legal effectiveness. Critically, several proceedings were filed before Her Ladyship's removal was finalized. These are contemporaneous constitutional challenges asserting fundamental and irredeemable flaws in the Article 146 process. The removal proceeded despite these pending objections. These objections now remain unresolved before multiple courts of competent jurisdiction. Mr. Speaker, we, the minority, hold the view that there has been inconsistency in the approach in this matter, and that if care is not taken, this country that we all seek investment for may not attract that needed investment. Mr. Speaker, as we speak, the prima facie findings of the Council of State remain unpublished. 2, as we speak, the very report that recommended...
Honorable Member, I thought your reference to this matter was a matter before the House.
Yes, Mr. Speaker.
But what you are talking about is not before the House.
Mr. Speaker, then let me use the phrase well. Let me rephrase it for the purpose of clarity. Mr. Speaker, my submission is to the effect that the matters giving rise for this motion to be taken are such that we, the minority, still believe that there are serious matters for the Constitution of our Republic. Mr. Speaker, and I say so because today we consider this nomination, and you have made it clear that our approval or otherwise does not bring a finality within the context of the rule of law, which I agree. I'm not contesting that. But it is our view, most respectfully, that one, the fact that the prima facie determination is not in the public space is of concern to us. 2, the fact that the recommendation, the report that gave rise for the final decision of His Excellency the President is also not in the public domain is of concern to us. Mr. Speaker, we contend that for the purposes of transparent democracy, the era where the citizens require information, it should have been an instinctive, inherent decision to have released a report. Because, Mr. Speaker, we hold a view that this was no less a matter because it was dealing with an organ of government, of state, the judiciary. That is our contention. Mr. Speaker.
Honorable Member, as I said, you are complaining about acts of another arm of government.
Mr. Speaker, I hope my time is being stopped.
Not Parliament. Not Parliament.
No.
And those matters are not before Parliament. And so I have consistently guided you and your colleagues to deal with the matter before Parliament. Continue with the others at the proper forum, not the floor of Parliament.
Mr. Speaker, we are not litigating those matters in Parliament, but those matters gave rise to this, what is before us. So what I'm trying to do is to give a background to the very matter before us, Mr. Speaker. Mr. Speaker, the Honorable Eric Opoku in his submission argues with some force that executive manipulation started in Kufuor era. I found it very rich. And he tries to use that to justify the concerns that we are raising, to say that we are acting in double standard. No, Mr. Speaker, in President Kufuor's era, no Chief Justice was removed. Mr. Speaker,
Honorable member,
Mr. Speaker,
please. I don't want us to go beyond what is before us, because many of the things that you say, because many of you were not born early, you don't know, you don't have the information. And in fact, I have bought some books, and I'm going to distribute the books particularly to leaders, so that you read to see the perception that we have given to the people outside there. They are very senior, intelligent people who held high office of state, who have written some books about Ghana politics. I have the books. I bought plenty copies to distribute to you free to read. I believe that will change your approach to how you go about the business on this floor. The information that I have from experience in this house, if I disclose them, many of the things you say are incorrect. The presidents and former presidents, they know. You don't know. And they know that I know what I'm talking about. So please, confine yourselves to the matters before the House. Let's deal with that one.
Mr. Speaker, we are saying that the fact that there appears to be some right violation against Justice Araba Isaba Tokunu, we in the minority are unable to support this nomination. Mr. Speaker, the learned Attorney General, in his submission, alluded to the fact that even when Parliament approves this nomination and the court determines otherwise, the executive would be bound to respect it. He was right in saying that when a court makes a pronouncement, the executive will be bound by it. But what he did not say is the conduct of his office in the handling of the very matter that he is saying when there is pronouncement, they would be bound by it. Mr. Speaker, he himself submitted that the rules of court allows for extension of time application to be made. The question we ask is that why didn't the Attorney General considering the enormity of this matter, act with alacrity. Mr. Speaker, the question that begs for an answer is that for all these periods, if justice was really meant to be done, why didn't the Attorney General file a defense? He is now saying that we shouldn't worry, and that if there is any positive outcome, the president will be bound by it. But we are interested in the process. The minority in this house is interested in the process, and it is contending that his actions amount to bad faith and denying the respected
Honorable Minority Leader. Honorable Minority Leader.
Yes, Mr. Speaker.
I acknowledge that the minority is interested, and you are expressing your concerns. And those concerns have also been expressed at the right forum. But I say this is not the forum for that. The Attorney General's conduct of conducting proceedings in that court is not before the House. That at all is not. And so please, let's handle what is before us. Then at the appropriate forum, which you are doing, you continue with it. You can just refer that this is what you are doing, but don't go into the details.
Speaker, with respect, Mr. Speaker, just place my time on ice for us to interrogate this preliminary matter. Mr. Speaker, well, I will leave it to you, but I would want to learn. Mr. Speaker, in my submission, I was responding to the Attorney General. These are facts that he has made known to the House. So I was responding to his own argument. I was not saying anything new. It is what he said that I was referring to. But if you say I shouldn't delve deep into it.
I stopped him.
Mr. Speaker, very well.
I stopped him.
Very well.
And I said he should come back to the subject matter on the floor.
Very well. Mr. Speaker, that's
please.
All. Mr. Speaker, if it is so, I will not belabor. Mr. Speaker, today, our colleagues who vehemently opposed just 2 nominations to the Supreme Court, and when they had the opportunity, they brought 7. Their principled argument vanished into thin air. Today, Mr. Speaker, when our friends in the NDC argued against 2 nominations to the Supreme Court, when they had the opportunity, they brought 7 at a go. Today, the same people who opposed this nominee in 2008 are today saying that they are for his cause. Mr. Speaker, we leave everything to posterity. Every single thing that we are witnessing in this house is for posterity. But we believe as minority that in spite of all that is happening, which happenings is affecting the rights of a citizen, the best days of our country are ahead of us. Mr. Speaker, we would not belabor. We maintain our opposition to this nomination, and we reject same, and we are going to demand a secret ballot to reject this. We are going to demand a secret ballot to vote, to let Hansard record our opposition. Mr. Speaker, we know that there are members who have their own views and would want to exercise their right when there is secret ballot. We, the minority, are going to invoke that so that we take a secret ballot to register our dissent on this matter. Mr. Speaker, I wouldn't exhaust the 15 minutes. I will submit here to and then leave the matters to rest. Thank you so much.
Honorable members, the last person to have a say on this matter is the majority leader. The minority leader actually used less than 15 minutes. So it's the majority leader who is now to end the debate, and he has 15 minutes to do so.
Mr. Speaker, mine is a very brief one, very brief. In 2012, we had a national election for the presidency and for parliament. The election results were disputed. President Akufo-Addo was declared winner. John Dramani Mahama and the NDC petitioned President John Dramani Mahama was declared winner. Akufo-Addo petitioned the courts. Mr. Speaker, in 2020, we had another election, and President Akufo-Addo was declared winner, and John Dramani Mahama petitioned. The cases traveled before the Supreme Court, and finally, the Supreme Court made a pronouncement. Mr. Speaker, it was clear to every Ghanaian that in spite of the cases pending in the Supreme Court, we went ahead and swore in those declared by the Electoral Commission as having been validly elected. But the case went on, and in the case of the petition against John Dramani Mahama, it was in August 2013 that the Supreme Court handed a ruling. Mr. Speaker, when we put the question to the nominee as to what he thinks will happen if the previous Chief Justice's case turned out in her favor, he simply referred us to these two cases. If in a presidential petition, we are convinced that if the ruling goes against a sitting president, that person will vacate the seat so that the winner will take over. Why would we entertain doubt that if a Chief Justice who has left office gets a ruling in her favor, that the sitting Chief Justice will not give way so that the decision of the Supreme Court will be enforced? So the answer is simple. We have to proceed. And when the decisions of the courts come, and the implications are that what has happened should be reversed, the Chief Justice nominee said he is ready to give way, and whoever the courts declare in favor of will come and occupy the post of Chief Justice. So there's no problem. Mr. Speaker, the second issue about the listing of cases was put to the nominee, and the nominee explained that he, as acting Chief Justice, is not responsible for listing cases. So if the minority's position was that some cases hadn't been listed, then that is a matter for the registry, because as an acting Chief Justice, the Chief Justice normally empanels the court when the registrar indicates that all the processes had been concluded, and then we had reached a stage where we would need to empanel a court. So he wasn't responsible for cases not listed. Mr. Speaker, I think that a lot has been said already about the nominee, and I will not belabor the point, except to once again, lastly, register the point that in 2012, July 24th, 2012, Justice Theodora Wood was nominated, approved by this House, and appointed a Chief Justice. 2013, January, President John Evans Atta Mills, under the NDC, became president. He coexisted amicably with Justice Theodora Wood, who was appointed by President Baffoe under the NPP. Mr. Speaker, again, on 24th of July, 2012, when we lost the president, John Dramani Mahama took over as the president, and he coexisted amicably with Justice Theodora Wood, who was appointed by President Baffoe, an NPP president. What is my point? My point is simple, that the NDC under President Atta Mills and under the current president, John Dramani Mahama, has coexisted peacefully with a Chief Justice appointed by the NPP. So, Mr. Speaker, let me conclude by saying that my colleagues have already argued and given reasons why we should approve the nomination to the post of Chief Justice, because essentially he qualifies under Article 1284 of the Constitution, has been a judge for 30 years, overly qualified, has been a Supreme Court judge for more than a decade and a half, and is now acting as the Chief Justice. Mr. Speaker, without saying more, I will just say that put the question and we will vote. Thank you, Mr. Speaker.
Honorable members, at the conclusion of the debate, I put the question. Those in favor of the adoption of the committee's report, say aye. Aye. Those against, say no. Honorable members, I put the question again. Those in favor of the adoption of the report of the committee, say aye. Those against, say no. Honorable members, I think the ayes have it. Honorable members,